This video will discuss Federal Rules of Evidence 407 through 411, the so-called Specialized Relevance Rules. Rules 407 to 411 all prohibit the introduction of evidence in specific situations. These rules are specific applications of the balancing test of Rule 403. In other words, certain types of evidence have been deemed to be unfairly prejudicial or capable of confusing the issues as a matter of law when introduced for certain purposes. However, Rule 403 continues to apply as a backstop to each of these rules. So you should first ask whether the Specialized Relevance Rule excludes the evidence for the purpose it's being offered for. If not, the court may still exclude it under 403 if its probative value is outweighed by the danger of unfair prejudice, confusion of the issues, delay, etc. With all of these specialized evidence rules, it's important to keep in mind the purpose for which the evidence is prohibited. In all but one of the rules, evidence is only prohibited when offered for a certain purpose, but is otherwise admissible for another purpose. 407 deals with subsequent remedial measures, which are defined in the rule itself as measures taken that would have made an earlier injury or harm less likely to occur. It covers situations like a product manufacturer's addition of a safety feature to that product after someone was injured by it. In order to encourage people to take these safety precautions, the rule prohibits evidence of them to show negligence, culpable conduct, a defect in a product or its design, or a need for a warning or instruction. By prohibiting the introduction of evidence of the remedial measure to show fault, the rule encourages those very measures and prevents them from being used as some kind of admission of liability. It does not prohibit evidence of a subsequent remedial measure if introduced for another purpose, such as impeachment, or if the party disputes ownership, control, or the feasibility of precautionary measures, then the evidence may be introduced for that purpose. For example, a hospital's decision to change its protocol to restart a drug if a patient's surgery is delayed may not be introduced to show the hospital was negligent in having the prior policy of not restarting the drug. If, however, a representative of the hospital were to testify that the newer protocol was not possible, then it would be deemed to have controverted the feasibility of that precautionary measure and open the door to its introduction. Another example is where a person chains a wolf after it attacks a dog. The fact that he chained the wolf afterward will not be admissible to show he was negligent in not having him chained before. However, if he denies ownership or control of the wolf, the fact that he chained it is admissible to show he did own or control. Next, Rule 408 covers the admission of settlement offers and negotiations, referred to in the rule as compromise. Clearly, prohibiting those offers from being used in evidence will help encourage parties to settle. The rule only prohibits such evidence when it's offered to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or contradiction. So when a person denies liability, the other party cannot say, yes, you're liable, that's why you offered me $20,000 to settle the case. Two types of evidence that are covered under the rule are first, furnishing, promising, or offering, or accepting, promising, or accepting a valuable consideration in compromising or attempting to compromise the claim. In addition, it's introducing conduct or statements made during those negotiations to prove or disprove the validity of the claim. So the offer to accept the amount of money itself, plus statements made during those negotiations. Except in a very narrow instance when offered in a criminal case and the negotiations related to a claim by a public office or agency with the exercise of its regulatory, investigative, or enforcement authority. This narrow exception will apply when someone is being investigated, for example, by the SEC, and makes statements to the SEC, probably knowing that those statements can be used against it in later negotiations. And so that is a different discussion there. The court may admit this evidence for another purpose, such as proving bias or prejudice, negating the contention of undue delay, and proving an effort to obstruct a criminal investigation or prosecution. So keep in mind the rule only prohibits this evidence to show the validity of a claim or to impeach by a prior inconsistent statement or contradiction. It will allow the evidence for one of these other purposes, like showing a witness's bias. So imagine two people are riding in the same vehicle and are involved in an accident. One of those two settles with the other driver and then testifies at trial favorably for that other driver. The other plaintiff, the passenger of the first car, can impeach the second passenger with evidence that the defendant offered that passenger a generous settlement, and so the witness is therefore biased in favor of the defendant. 409, payment of medical and similar expenses, is both broader and more narrow than the 408 rule on settlement negotiations in general. 408 only covers offers to settle a disputed claim. So if there is no claim yet, 408 won't apply. 409 does not require that there be an actual claim yet, but 409 only prohibits offers to furnish or pay medical, hospital, or similar expenses occasioned by an injury. It does not cover an offer to pay for damage to a vehicle, for example. Again, the rule only prohibits introduction of the evidence to prove liability for that injury. It won't encourage humanitarian offers to pay personal injury expenses, but the rule does not prohibit other types of offers or any statements made surrounding the offer. So it's a very narrow piece of evidence that is prohibited here. The next specialized relevance rule is 410, which covers the introduction of guilty pleas and statements made during plea negotiations. It prohibits the introduction of such evidence in a civil or criminal case, and importantly, the rule prohibits this evidence, period, not solely when introduced for a certain purpose. So whereas other rules only prohibited certain evidence when offered to prove a particular thing, like negligence or fault, 410 prohibits evidence of guilty pleas altogether. The following is not admissible against the defendant who made the plea or was a participant in the plea discussions. An important point here. What's covered by the rule is two types of pleas: a guilty plea that's later withdrawn, or a nolo contendere plea, where they don't concede liability. Also prohibited here are two different types of statements: statements made during a proceeding on one of these pleas under Rule 11, or statements made during plea discussions with an attorney for the prosecuting authority. Keep in mind, first, the rule itself only prohibits this evidence from being offered against the defendant. It does not prohibit this evidence when offered against the prosecutor. However, some courts will find such evidence should not be introduced against the prosecutor either under 403, since this would discourage prosecutors from making offers. Second, keep in mind that the evidence here prohibits two types of pleas: guilty plea later withdrawn and nolo contendere, and the statements made during a proceeding on one of those pleas under Rule 11, and statements made during plea discussions. Importantly, this last type of evidence does not cover statements made voluntarily or spontaneously by the defendant. Instead, they must be during, quote, plea discussions. And it's not going to cover statements made to a police officer, for example, as opposed to the prosecuting authority. Only if that police officer has the authority to act on behalf of the prosecutor will statements made 410 prohibits this type of evidence from coming in, period. There are a few exceptions here that are pretty narrow. And the exceptions apply only to statements made surrounding the pleas. The exceptions don't apply to the guilty plea itself that's later withdrawn or to the nolo contendere plea. So first, in a proceeding in which another statement made during the plea discussions has been introduced, then one may come in under this exception if, in fairness, they ought to be considered together. So this means that a statement is introduced and doesn't violate the rule. For example, maybe it's offered against the prosecutor, and the court finds that way. Then the prosecutor may use this exception to introduce a statement against the defendant, because in fairness they should be considered together. The second exception allows statements to come in when the defendant is charged with perjury or false statement. There are two very narrow exceptions. Otherwise, this evidence does. The last of the specialized relevance rules is 411. It prohibits evidence of insurance in order to prove that a person acted negligently or otherwise wrongfully. So a plaintiff would not be allowed to offer evidence that the defendant had car insurance to show that the defendant was driving carelessly. And a patient couldn't bring in evidence of a doctor's malpractice insurance to show that the doctor was negligent. But the law does not prohibit the evidence for all purposes. It is, in fact, admissible for any other purpose. And the rule lists some of these examples, but they're not exhaustive. Bias or prejudice or proving agency or control. Any purpose besides showing negligence or wrongful conduct is permitted. An example of bias. If a witness on the stand testifies in favor of the defendant, the plaintiff might show that that witness is insured by the same malpractice mutual insurance liability carrier. And so, bias her testimony in favor of the defendant because her premiums could be affected if the defendant was found liable. That is the example of bias. Or if a party denied that they owned a particular vehicle, then the fact that they purchased insurance covering that vehicle would be admissible to show ownership or control. Remember, any time that evidence is introduced for a non-prohibited purpose, the judge may issue a limiting instruction to the jury. For example, the judge might say, members of the jury, you have heard evidence that the defendant's expert witness shares the same mutual insurance company as the defendant doctor. This evidence is only admissible on the issue of whether that witness might be biased in favor of the defendant. It's not admissible to show that the defendant was or was not negligent. It applies to all of the specialized relevance rules, not just the one about insurance. Finally, when evidence is admissible for a non-prohibited purpose, it still must survive the balancing test of Rule 403. So the first question is it prohibited by one of the specialized relevance rules? Then, is it prohibited nonetheless by 403? The defendant doctor in our previous example could argue that the probative value to show the expert's bias is very low, and the risk of unfair prejudice would be that the jury will find for the plaintiff because they know that there is insurance to cover it. Substantially outweighs that probative value. The court may exclude it on that alternative.